keep this.
Okay, dear people, I guess we can proceed.
I'm just joking.
With the conference this time with full bellies, because we've rescheduled the time frame a bit. I'm going to give the word to Julieta Rabanos and Bojan Spaić, who are going to talk within the section of AI and application of law on the topic of the death of legal author, artificial intelligence, and the authority of the law. So without further ado, I give the floor to them.
Well, thank you very much, Sava. Thank you very much for all of you to be here and to hear this. But we will see how it works. Before starting, a little bit of context of discovery in this sense of the topic. I come from the field of authority, and he comes from the field of interpretation in a wide sense. So we arrived to this point in which the two of us had the same intuition about the same object, but coming from different places. So this presentation is the both of us trying to do this intersection between these two topics, and then being somewhat provocative with this title. Okay, this was so dramatic and the slide didn't work. Fantastic. Okay, we have all seen that ChatGPT and all these generative artificial intelligence machines or black boxes or basically algorithms have been being used more and more, at least in notorious cases. For example, these ones, like a Colombian judge that says that he used ChatGPT in ruling, that a Court of Appeal judge praises ChatGPT for being very useful, that a judge has been sanctioned for sanctioned lawyers for use ChatGPT because ChatGPT had invented some specific cases that didn't exist. So after all of this, we have different issues that maybe we can try to tackle. For example, that we have a technology that has developed capable in some senses that we have been trying to guess in the last, for example, presentations, this capability of producing texts and including legal text in this production. So in this sense, the frameworks of philosophy of law for us, for example, do a solid job in explaining maybe human creation of legal texts and human interpretation of legal texts. Then we had a presentation wondering, for example, Palka's presentation wondering how, for example, the emergence of artificial intelligence maybe challenges these assumptions or maybe challenges some presuppositions about the theories of law. So that was very interesting for this. But then, at least contemporary theories or frameworks of philosophy of law do very well with human creation and interpretation of law, but we wonder if they do the same with maybe non-human creation and interpretation of legal texts. In this sense, in this presentation, we try to identify some problems and propose some, or at least a tentative philosophical solution to the issues that arise from this possibility that this emergent technology has already, and it will increase in their capabilities to produce even more. So this technology that is able to produce a legal text, and if these texts could be or will be conceivable objects of legal interpretation by humans or by other non-humans entities. So in this sense, when we analyze this question about this technology in particular, we have at least two problems in or for philosophy of law. One related to the technology in itself and the problems regarding, on the one hand, the authorities, and on the other hand, the interpretation. Naturally, you can subsume this second issue within the problem of authority if you think about the people or the subjects or the entities interpreting the text being also legal authorities. But then, for the purpose of this presentation, we are going to separate these issues. So the technology, or a question about the technology in itself, is obviously, can generative AI create sources of law? This is not an issue about should generative AI create or not sources of law. We are, in this sense, just trying to answer if it, as a matter of fact, can, at least in our definition or in contemporary definitions of what a source of law is. Then some problems, for example, regarding authorities and regarding this human authority and possible machine authority like Skynet or HAL 9000, or in this case, ChatGPT. So there are two main issues. One is if AI, maybe not ChatGPT, but maybe in the future, can be seen as an authority of some kind. And then we can discuss about if it can be seen, for example, as an epistemic authority and not a practical authority, or if it can neither one nor the other. And then naturally, if we say yes, there is the issue about if the authority of these artificial intelligences can be justified in some sense. So if they can be some sort of legitimate authority. And in regards to the interpretation of the generated legal sources, one main question for us would be basically the main question in this presentation, that can generated legal sources be interpreted by a human interpreter, in the sense of generated by artificial intelligence, because in some sense you can also say that the parliament generates legal sources. Okay. The first thing, naturally, when we are trying to tackle the idea or the questions about creation of law, is to try to determine what creating law is. In this sense, the question about what is created when we create law, we can conceive of sources of law as artifacts, or at least traditionally it has been interpreted as some kind of artifacts that are produced when we create law, which are these general legal norms. Then within this idea of creation, of what is created, we can find, for example, sources of law, and then authoritative interpretations of these sources of law, and naturally these interpretative attitudes of the community regarding the sources of law, and then the interpretation made by some specific authority about the sources of law. Then when we move to the question about what does creation of law entail, we can start with a very classical definition about that creating law is the enactment of a source of law to create a legal norm, rule of principle, guiding some kind of conduct. So we have some kind of utterance or some kind of production of some kind of text with intention to create, or at least this is what we want to discuss in the presentation, with this intention or this purpose of this idea that you are creating that to create a norm that will guide some kind of conduct. And this norm can be seen in a very wide sense as some kind of prescriptive statement. Looking at this in this way, at least in this traditional or common sense idea, legislative authorities or legislators are considered to be agents. In this sense, traditionally, it is understood that creation of law presupposes an author of this law, being the text and or the norm, capable of intending to guide conduct. So capable of communicating, capable of producing this statement, capable of communicating this statement, capable of communicating the intention that this behavior is to be guided by this statement, because this statement was communicated and so back and so forth. Then we used ChatGPT, and we gave ChatGPT this basic prompt: act as a legislator, not a judge, which was like the prompt in the first presentation that Bojan and Miodrag gave, and then also in other presentations like Palkas. We said, act as a legislator, draft a statute prohibiting the carrying of guns in public places. So the ChatGPT version 4, I think, right?
Yeah.
Version 4 produced this very brief draft, which includes the name, definitions used, some dispositions regarding the prohibitions, some exceptions, some penalties, the way in which this is to be implemented, and some kind of severability about the dispositions of the same draft. As a person that has worked in a national parliament, I can say that this is way better than the majority of the things that I have seen when I was working in the national parliament. But then naturally, this is a very, very, very basic statute. But it, just with this prompt, ChatGPT has already produced this with this structure. And understanding that there is a distinction between the definitions, the dispositions carrying some kind of normative, like deontic, full-blooded deontic, not intention, but basically direction. Then the idea that there are some exceptions that can be thought about these prohibitions, so the prohibition not being absolute, some penalties, some sanctions according to these rules and exceptions, and then about implementations and about severability. Do you want to say more about the prompt?
No, about the prompt.
Okay. So let's go. So maybe you can have a difference between this idea of creating law and the idea of generating law, and then you can ask yourself whether an AI can create law, at least law as we traditionally conceived. So one specific question is, what is created when an artificial intelligence generates law, or at least this type of statutes with this prompt? So in this sense, we think that conceivably artificial intelligence can create sources of law in the sense of legal texts, dispositions, normative dispositions. It can do legal research, it can draft private law acts, and it even tries, but fails, to create acts in the domain of public law. Then what would generation of law entail? Not creation of law, but generation of law, at least in this sense. For us, generation of law entails the production of a source of law by generative artificial intelligence based on a prompt by a human prompter. So when we talk about generation of law in this presentation, or when I talk about generation of law in this presentation, I will be referring to this definition. And then the question that arises here is about clearly one missing, or at least one missing piece that could differentiate between creation of law and generation of law, which is intention. If we have defined creation of law as the enactment of this statute, blah, 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 with the intention of it guide the behavior and so back and so forth, this seems something that is missing from at least this idea of generation of law. So in this sense, it can be said that there is no intention behind the generation of law by artificial intelligence. Still, and this is something that we will develop more in not the future, but then in a couple of minutes, the result of the generation might be as approachable to the reader as intentional creation is, if not more. And this is something that we want to build on.
Yeah. So you saw in this simple prompt that it is quite conceivable that we'll have something like the machine generation of public law documents or statutes, but we are not there yet. We are very far off. It might be because this is a general purpose consumer-oriented product. It might be because of a lack of fine-tuning or whatever. But that doesn't stop us from thinking in terms of possible scenarios of involvement of artificial intelligence or large language models in drafting, especially drafting public law documents? Well, one scenario that is basically what we have now is the AI enhanced human authorship of legal documents. For example, an AI finely tuned to do legal research, comparative legal research, would be capable of giving the human legal author valuable data on the regulation in comparative and international settings and about the available scientific research data. In this first case, it would seem obvious that the authorship by the human author is maintained, in the sense that the human author was just aided, he used AI as any other tool or as Google. Authorship is maintained absolutely if you Google something in order to reach a conclusion. The second possible scenario that we thought about is a bit more problematic. So it's human prompted and evaluated AI authorship. So this is the situation basically like our prompt, in which the human is the one giving the prompt and eventually evaluates the result. Eventually just evaluates the result of the artificial intelligence. In this scenario, I think it's reasonable to claim that there is a kind of a joint authorship between the human and the AI, in the sense that most of the text was actually produced by the artificial intelligence, and that only the initial impetus for the production of the text and the final verification came from a human verifier. And finally, we call this one the Gerald Postema scenario, also the Supreme Intelligence scenario, or just shortly Skrull scenario, which is raised from Marvel Comics, which I won't go deep into explaining, but you can see it pictured here. There is allegedly a race in the Skrull world. The Skrulls are a people who decided that they are going to give all control to a supreme intelligence. And when we talk about the epistemic authority of artificial intelligence, this is the extreme case of epistemic authority of artificial intelligence, where you surrender your behavior completely. Why is it the Postema scenario? Because actually in Law's rule, Postema argues against the supreme intelligence of the Skrull mainly. He envisages a scenario in which all law would be replaced completely by artificial intelligence, and then compares advantages and disadvantages of this of artificial intelligence regulation and legal regulation. I'm sorry that Šemek is not here anymore, because he was talking about these out of this world mental experiments, or with one. This is one of those experiments. Anyways, in this third case, all authorship by humans is lost, in the sense that AI is completely producing legal documents. Now, we will discuss in the next slides the second scenario and the third scenario, basically because in the first scenario authorship is completely kept on the human side, and we don't really have a problem in asking questions about interpretation and creation or generation of legal text. So let us start with these questions of authority or possible legal authority of AI.
Yeah, so trying to discuss or trying to go in depth about this idea of authorship and authority in the sense of authority. So we know that basically when you talk about authority in or of law, there are several interconnected trends of questions, but what one trend of understanding the issue that is specifically of use here is about the issue of authorship of certain objects that have certain characteristics that have been produced by certain means, which is basically what we are interested in. So a possible starting definition about this idea of authority is a subject or an entity issuing certain prescriptive statements with the claim of being authorized to do so. and then of being justified in demanding that the addressees take them, these issuings, as a particular reasons for action, which is basically the definition of Joseph Russ within legal theory. So even if we cannot agree absolutely with this definition, at least this starting definition makes us think that this authoritative relationship, or this scenario in which we are when we have this kind of output and then maybe an author and maybe someone that receives this output, is a triadic relationship between something or someone that we called the author, something or someone that we called the addressee, and then the output mediating between the two of them. So going now, if this is the idea of authorship, authority, and the relation, one thing that we just introduced but we didn't touch upon was this idea of intention, especially relating with this idea of generating legal sources, not just creating legal sources, but generating legal sources. So what is intention? Well, this is something for a full other presentation. But here you can basically say, also an asterisk. You can have several levels of intention, and this is another problem for another day. But, yeah. So when you talk about intentions, you can go in two ways possible. Or practical attitudes that play crucial roles in plans that agents commit themselves or others to, for example, Bratman's definition, or you can go towards the idea of mental states that acts as reasons for action, which is the Anscombe idea. What has to do with generative AI, this idea or these definitions of intention? That generative AI displays behavior that is commonly characterized in psychological terms. Or I am saying that she is not convinced. So, okay, let's discuss. So basically, some descriptions about what AI does is, at least from some people, described in these psychological terms. This idea of emerging behavior and emerging reasoning, hallucinations, biases, this seems quite psychological for us. So it is even argued that already in GPT-4, we have sparks of...
General artificial intelligence.
Yes, thank you. Okay, general artificial intelligence. So all explanations of this phenomena seems to us really behavioral, like ascribing behavior to artificial intelligence. But we have a little knowledge of the inner workings of generative artificial intelligence, and most probably it does not have any inner life to speak of. Maybe, as we have seen here, we have some more explanations about how this works. For example, Masha was trying to explain this with fantastic graphics, but in general, we still are thinking in this idea of the black box, and then that we don't really know what is going on there.
Well, at times, so there's no intention or inner life to speak of, and when we are able to interpret this thing, it becomes very bizarre. And this is what I was talking about when I was talking about product and process rationality. Mm-hmm. This is the easiest example. So this algorithm that you see is the resulted in a calculation that states 2 plus 2 is 4. The calculation is based on this modular addition algorithm. This Neil Nanda at DeepMind trained actually a tiny transformer to do addition. Then he spent weeks trying to understand how the transformer is doing addition. And he managed to understand how it does addition. So this is the algorithm that it created to add two numbers. Now, we are not sure what our brains do when we calculate two numbers, but it's kind of very difficult that we create this kind of algorithm to calculate 2 plus 2. So even if we have a result, a product that is rational or irrational, that doesn't seem to indicate that there is a rational process behind it, or that there is something akin to human intention, mental state, or reasoning, or anything basically at all behind this idea. So no intention and no mental state to speak of in artificial general intelligence as of now.
Mm-hmm. So with this in mind, we have two main questions that can be restated. One related to if the author of something that we call a legal text need any factual intention in the production of this output for it to have certain characteristics, for example, being prescriptive or have certain content, or would it be sufficient that it is presupposed to do so in some context or by some people? And then the second question is the role of the addressee, because traditionally the addressee have been thought to be a more have a more passive role, just receiving and then at some point discovering the context, the content of these outputs. So in this sense, the second question would be, does the addressee play any role in the confirmation of the characteristics of the output through, for example, interpretation, or is it to be considered a merely passive part? And with these two restated questions in mind, we can move, we can move to basically the idea. If we think about these, and these are the two questions, maybe we can think about that the problem is how we conceive of, for example, legal texts and legal norms. So how we conceive of the output. Because these outputs are naturally cultural products that are possible objects of interpretation, and then it is clear that in our practice there is an ubiquity of intention, for example, in legal interpretation. And for example, Fish says that interpretation is impossible without intention, but because the presupposition of intention is a condition for the possibility of understanding any designed or purposely produced object. But in this sense, this presupposition is not necessarily correlated to the existence of intention on purpose. It's just a presupposition that the addressees need when they are trying to analyze some cultural products. And this goes absolutely hand by hand with at least, for example, some theories regarding what is the production of legislative authorities. For example, Karol Krona, that says that legal norms are independent imperatives, so they don't depend on any will or intention to have strength as imperatives, nor about their content. They are basically in the hands of the addressees when they are labeled law. And this is more complex. We can go on in the discussion. And then, for example, you have other position, Francesca Poggi's, that says that there is nothing in the legal context akin to the intention, for example, of an ordinary speaker in conversation. There is only the possibility to have some kind of intention in the sense of collective intention in the producing of a text, but not of the meaning of that text. So in this sense, but she says that we cannot do away with intention, at least in the way we classically think about intention, because our intuitions about norms being the expression of will or intention of someone, they are too strong. So we can't do away with them, even if we don't have some intention to be found in this sense. So some preliminary answers to these questions, according to what we have tried to say. Regarding the first question, so our tentative answer would be that it might not be necessary to have any factual intention on the part of the author of a certain output regarding at least the meaning of that output. It can be a text without any necessity of having the intention of that text expressively meaning something. In this sense, it seems that it is perfectly sufficient to have that intention presupposed by the addressees or the interpreters of the output, and even more, it might be the case that the only role of the author is the decision of ascribing some label to some output following some procedure. And then, regarding the second question, the role of the addressees of interpreters can be seen as extremely important, maybe even constitutive of the output, at least in the consideration about its characteristics and content. And then this is some challenges that, if these holds, are now open, for example, for theories of philosophy of law, under which specific conditions can AI be considered as a legal authority of some sort, being epistemic or practical, under what conditions, if any, can AI be considered as a legitimate authority, and naturally something that Pedro maybe is going to tell us, how to interpret AI-produced legal text. So thank you very much, and we want to say that we didn't prompt the AI to do this middle finger to, yeah.
Yeah.
Thank you. Yeah.
Yeah, we like to think that it is, because we prompted it kind of 10 times.
That's your interpretation.
Yeah, we just prompted it like, do something with death of the legal author, and then this. Okay.
Thank you both for a very interesting lecture. You've opened a lot of questions. I haven't actually anticipated, but it fits quite well into the last topic of the session, the creation of law. Now it's time for the Q&A part. We can collect the questions as we lack the time. Yes, please.
Great paper, very interesting. Just two things for intuition tests, if you like. The first one, aren't you over-engineering the problem? Think of a smart traffic system already in existence, which takes sensor data about traffic density, road conditions, rain, and then has these huge digital signs on the road that say, from now on, maximum speed is 90 miles if you are in a personal vehicle. So unlike a traffic light, just to make it even closer to what you are doing, it produces a text. It's not an individual order, so not the police officer telling an individual car, a general rule, a general norm. You should now drive with 60 miles per hour. We use the normal rules of interpretation. So if you as a driver realize my car is on fire, the only way to get out of safety is speed driving, you will still do it. Wouldn't that be a norm for the purpose of your talk, and one that is entirely AI generated and obligatory? And on the other extreme, something that I found in international private law, some people putting in the clause of their contract, this contract should be adjudicated according to the rules of the Republic from Star Trek. So here you have legal rules that were from the author never intended to guide actual behavior, but still we were able to give them that meaning. By a sort of community that says, oh yeah, let's do this. Let's adjudicate according to these rules. So the intention of the original author wasn't to create laws, but it acquired the function of being interpreted like a law. How would you deal with these two extremes, if you like?
They'll definitely both go in the paper. So
Absolutely.
thank you.
Absolutely.
They're both going in the paper. It is over-engineered, the example, because of the scenarios that we basically did. So we're just actually considering this seriously, these two scenarios in which the AI is basically able to alter the thing by itself. Whenever we have some human mediation of this, it's kind of possible at least to, and as we argued, I agree with both Oliver Krohn and Poggi in this sense that attention doesn't play a significant role. But I think, and I didn't do a survey that I'm kind of in the minority, in the sense that people usually usually connect, or even textualists, what they're interested in the text in order to uncover the intention behind this text, or if there are some intentions. So there is this presupposition of intention always when we do legal interpretation. For example, Fish goes as far. So if you found something written by waves, and waves all of a sudden write SOS for some reason, that doesn't mean anything. That's Fish's idea of. So because it has no true meaning, because for something to mean at all, you need an intention behind it. So what the puzzle is actually is kind of like, can objects that are not intended be meaningful objects of interpretation? And yeah, we all know that there is astrology, but like for reasonable persons, can these objects be? So I think that in this case, in the first case, it fits perfectly with our third solution in the sense that there is something, that there is already something that's in need of interpretation without human agency being behind it. That's the first thing. As for the second thing, I don't think that it impacts this much, because we weren't claiming much about this intention to create a legal text or a source of law. We moved this discussion, and Jules was, I think, clear about this, or not. But yeah, basically, we were mentioning this idea that the constitutive role of the interpreter, but we already have it in law. For example, when we interpret indicative sentences to mean something normative and stuff like that. So it's a good example, but I don't think it takes much from the situation in which the reader is basically constitutive of the fact that a text is interpreted as a normative text. So that would be my answer.
No, I thank you very much for the examples. They are fantastic. No, I just want to say that I think that it all boils down to the recognition that you want to give to basically the authority of the interpreter. And this obviously comes with a position about a theory of interpretation. Absolutely. What we wanted to try to see if it was possible to have some output that had no characteristics as the traditional way to think, for example, of legal sources, and still be used in the same way, for example, by interpreters, to produce some results that, yes, are classic within this idea. And our proposal was just like, okay, it might be, under these conditions, it might be, and if it might be, then the third scenario, for example, the posthumous scenario, or the scroll scenario, it could be possible, and then naturally the question would be, should it be possible, or should it be worth it? And then, but this is a topic for another discussion.
Okay, Bojan was eager to answer the question immediately, but we can collect it first if that's okay. We have Masha.
So, a short comment. You had two scenarios in which, in one of the scenarios, there was verification. And like, to me, that kind of prescribes intention. If you verified it and decided this is like, human prompted and evaluated. Yeah, so there's, I think Bojan was calling it verification, not evaluation, but maybe you mean something else by evaluation. But like, if somebody evaluated whether this is valid or not as a legal text, then that's already like the intention of that person is then in that text, even though they might not, by just agreeing to it, sort of. So this was just, but in the third scenario, that's very.
No, yeah, I'm just thinking about this, whether we would kind of, if I prompt. Oh, sorry.
No, I was.
No, the collecting.
Oh, no. Yeah, true. There is any more question.
Sava is like.
The moderator.
Yeah, I'm. Sorry.
No, but fine. Maybe there aren't any more. Okay, Professor Mueller.
Obviously, there was a question.
I didn't want normally, but just because of you, I will now ask.
I'm going to use you in my next example, so
Okay.
just to mention mine.
I'm not sure that. No, okay, I get what you wanted to show, but in a way, I'm not sure whether you are really talking about the authority, because if we put aside this scenario in which you have this super intelligent creation which completely self-generate everything, which counts as law in one society, then we are left with a situation in which by the end of the day there is always some sort of authorization by the human. Like in this case, it's authorized by the human. Basically it gives the kind of authorization on the basis of very concrete circumstances, provide a guideline or provide a directive what to do. So in that respect, you are not so much speaking about the authority, or at least it seems to me that you are not speaking about authority. You are more speaking about something which has to do with legal drafting. How artificial intelligence is capable of producing text which would be, I don't know, good enough for the people to be guided by that very text, which is also a very important thing. I mean, it's a important philosophical task to dwell upon, but I wouldn't say that it's so big or important as if you want to connect it to the concept of the authority itself. I know that you wanted to stick to the problem of intention and the interpretation of something which is not intentionally created, but nevertheless, if it's authorized by the human, there is always some intention by the human of what we want to make with this AI product. So, for instance, you gave us a very simple task: produce some sort of statutory act which will prohibit guns in the public space, right? But what will come with more complex statutory acts, which has to cover various situations without, having in prompt already the main idea of what is the purpose of the law. It would be much harder to come up with a single prompt and to get a generated text which would be similar to the statutes as we know it. So I'm speaking about statutes. Obviously, it's a completely different situation if you want to use it for drafting of certain clauses in the contracts, which we heard yesterday in Schoenherr that it's functioning very well already. But then the question is, but that's a minor question, I didn't understand why the contracts count here as sources of law. I mean, that's what I didn't get. It was in one of the lines, but it's a minor issue. Okay, so that will be.
I think we have one more. Yes, please, Asha. The microphone, please.
This is not a question to the panel as such, but I've been struck with Professor's question, which was the example that he shared is, based on the circumstances, a digital board on the highway would prompt if there has to be an increase or decrease in the speed limit. So, most of the time, the systems that we have prove to be not 100% accurate or not even 80% accurate. And then these errors sometimes are fatal and very serious. And then probably if the panel would like to answer, in case if we have a fully automated a system and then you call it an authority, whom do we hold responsible, whether would it be the creators? Or yeah.
I'll be very brief.
Now, yes.
And give the floor, and give the floor, or I hope to be very brief and give the floor to Jules. Now, I want to understand whether I kind of missed this scenario because I just formulated it not so good. So what I try to do is basically the initial prompt contains an intention, but the text is entirely generated by the artificial. Now, we obviously, and we claim that we are not there yet. It doesn't work yet, but it's imaginable that it will work. And it might work in a few years if these generative things eventually start making longer texts. Maybe they can do it even now, because if you don't cap them to write a certain amount of text, I don't think it's a huge problem to technically solve. Now, my idea here is that the human is evaluating in the basic sense of, yeah, this goes, or yes, this doesn't go. So the role of the human is at the beginning and at the end. And now the thing is that kind of, and this is an intuition. If AI does this, the human prompts, the human says yay or nay. To claim that it's authored by the human, it's kind of my intuition. That's not my intuition, but I could I would say that it's co-authored by the human and the AI. I would claim that, but it might run counter to some other intuitions. As for Miodrag's questions, we weren't claiming that. We were just saying that the AI is currently good at doing private law things like drafting contracts and doing legal research. And we actually wanted to inquire into whether it can do public law acts. So that's how we mentioned. We weren't claiming anything about this source contracts as sources of law. What was your previous?
About legal drafting.
Yeah, I'm not sure about this, but Julieta will answer more. I don't really. So we were trying to do three things. There is this question of authorship, which we were dealing with here. There's this question of authority, and there's this question of kind of understanding products or generated legal texts if you don't have an intention, a factual intention behind it. And I understand you from the standpoint in which you claim that authority is not a question because it's a question of the the state. It's the state usually that has authority, so it's not the individual drafter that has authority. But in a way, in our both second and third scenario, the state would be behind this. Otherwise, it wouldn't be able to become law in this sense. So this question of the state borrowing its authority to persons who draft it or to AI who drafts it's a non-issue. So I think that Jules was mostly speaking about the authority in this sense that somebody authoritatively prescribes something, in the sense, and with the presupposition that the state is behind anything that counts as law.
Yeah, extremely briefly, when you talk about authority in and of law, this was the play. I don't know what I'm saying. It's because all the questions about where the authority comes from, if it comes from somewhere, need to be answered. So here you are not talking about legitimate authority in the sense of the authority of law. Maybe you are talking about authority in law, which is about competence. For example, someone is competent to do something. But then this discussion about the origin of authority and if we can say that someone is an authority or not, in that sense, comes from a different question that needs to be answered separately. So in this case, we didn't want to go into this because you have to take a lot of compromises if you start asking this question, which we try to just be very superficial in this sense. But I think that we have to take that into consideration for. And the only thing that I wanted to say, well, thank you, Masha, obviously, for the question. I would say that you introduced something that we have to consider when we draft and not with ChatGPT help, the final version of this paper, in the sense of that you introduced intention as evaluation. So you introduced the question about criteria to evaluate something. And I think that this was something also that was mentioned by Miodrag, because not always the criteria of correction of a decision, for example, comes or is related to the idea of legal competence, for example. You can have external criteria of correction or internal criteria of correction, and sometimes it's not linked, this criterion of correction, on intention. So you can evaluate, for example, in this second scenario, you could evaluate the output without a recourse to intention. But naturally, and this is something fantastic, we have to try to see what could be the criteria to make this evaluation, if any. And this is, I think, that something that comes with the challenges that we open, like how to interpret what are the criteria for this. And in the case of a fully automated system, I think that the question has to do with legitimation, in the sense of who is liable for something, comes with the idea of who can be made responsible for something. And if you have a legitimate authority, generally this question is, if it's justified, it is not liable, for example. They are naturally highly, very, how do you say this in English? Grace in this. But as a rule of thumb, if something is legitimate, it's not responsible or liable in this sense. So it boils down to the questions that are opened by this in the end. But thank you very much for your... Maybe we can discuss that, because I feel Sava here. Like
yeah, like there's some heat emanating from this side, which I want, and I wanted to stop.
Okay, thank you.
Thank you.
Thank you very much.
Thank you.
Okay, so great to be here, always. So I'm not an AI expert, far from that, and I will not be talking about interpretation, and never in my life have I been so many times mentioned before my presentation. So I will not be defending those ideas, just to say that paper, I really truly believe that textualism is the theory of interpretation as a meta explanation that better explains the interpretative process. But maybe David's different, but I do not feel comfortable in saying that I completely do away with intention. So just to clarify that, it's a matter of coherence with the Spaić Act, not a full-blown position on that. David, those of you who know him, he goes all the way with his theories. So I'm speaking about a completely different thing. I'm speaking about similarity in artificial intelligence. This is sort of an adaptation to artificial intelligence of some stuff that I've been in researching on equality, similarity, analogy, and specifically the building of categorization. So a lot of things have been written on similarity in artificial intelligence. Maybe, again, I will take a pessimistic stance, but I think that by saying what we are unable to do with AI systems will allow us to pinpoint research methods to better go through with these topics. So the general gist of it, I want to talk a little bit about similarity, then similarity in artificial intelligence, and then place similarity within analogical reasoning, and place similarity within analogical reasoning in artificial intelligence. So this is very ambitious. Let's see how it goes. So first thing, do take me a photo with a cat. Domingos? Just a photo with a cat.
That's very important.
It's here because of that. So yeah, me and the cat. Thank you. Okay, so there's a saying that's called that cats dread cold water. I don't know if it applies in Serbia. It's a very usual Portuguese saying, and I want to use it as an example of analogical reasoning. So the cat is wrong because once in his lifetime he was hurt by hot water, but then he's afraid of cold water because he confused the relevant similarity. So you should be afraid of hot stuff instead of being afraid of liquid stuff. So this is a matter of analogical reasoning when you wrongfully transpose the relevant aspect of the situation that previously gave you some stimulus on something. So there's two aspects that I will get back to later on. If you see Scalded Cat dreads cold water, there's a matter of relevant similarity. So the relevant aspect is hot, not water, and there's a matter of sufficient similarity. Like how hot would it be for the cat to be afraid of the hot stuff? So these are two aspects that I will go through later on. So apart from the cat, there's this passage from William James from 1890. Also relevant for analogical reasoning and the problems of analogical reasoning in artificial intelligence is because there is no essential property to anything. So machines have problems applying stuff from outside their training regimes, and this is of paramount importance to analogical reasoning. So they are trained for some scenarios. Masha has talked a lot about training, and then when they go outside those training scenarios, they really don't know what to do, because if they knew what to do, they would not be analogically reasoning. They would be just applying the data that was encoded into the system. So the capacity for analogy making and conceptual abstraction is a key feature of human evolution. I will skip this, we'll take this for granted. And similarity is seen as a key to this probabilistic assessment. It is key, but it does not explain to the full extent the analogical reasoning. So similarity plays a big role here, but it does not explain the full extent of the analogical reasoning. So there's two aspects that we should keep in mind with similarity. So basically similarity, in this very basic notion, we get that the higher the degree of similarity, and I'll explain what it means, between X and Y, the higher the probability of correctly inferring that X has Q upon knowing that Y has Q. There's an assumption here, and I've been very interested in Eleanor Roche's account of the psychological principles of categorization, is that for this to happen, we need to assume that the world is not an unstructured set of equiprobable events. So it's not a matter of chaotic anything goes. There's some sort of structure in the world that allows us to extrapolate from a certain event to another similar event. We may be wrong, but we have something that allows us to get from X to Y. Now, when we get to analogical reasoning, similarity in analogical reasoning, there are some problems that are general. They have nothing to do with artificial intelligence per se. There's general problems of explaining analogical reasoning, and then there are specific problems of analogical reasoning in artificial intelligence. I'll try to keep them divided. Some aspects have to do with theories of analogy, how inferential theories, for instance, the ones that I sympathize the most, but there are other theories of analogy, general problem, and then other problems, other aspects have to do with specific AI problems. That is, the non-redundancy problem, and I'll get back to this, of analogy is a problem in artificial intelligence because it leads to a paradox. If you feed the machine with certain criteria, then the machine is not analogically reasoning, is simply applying the principles or the rules or the standards or whatever to a given case, which is something that does not happen, at least in the mainstream theories, general theories of analogy. Now, to get to, I will skip the logical aspects of it. I'll just give a brief presentation. Before moving to analogical reasoning, similarity. So similarity is something that can be asserted, a relation. Similarity is a relation, and we can assert a relation of similarity between two objects or two terms. And we can measure that relation. There's several models, geometrical models, featural models, alignment-based models. This has been developed in general psychology, but also in artificial intelligence. I don't know much about these. I know a little bit about featural models that were developed by Amos Tversky in the 70s. So basically, the model is you have a weighted sum. So you need to feed the machine, if you apply it to artificial intelligence, with some sort of weight for salience or relevance of certain predicates. You have the weighted sum of the measures of all the common features within a category minus the sum of the measures of all the distinctive features. And with this formula, it will give you, so you have a certain parameter that denotes common features, another one features exclusive to one object of comparison, and the other features exclusive to the other object of comparison. If you apply it to artificial intelligence, you can do that. This was something that was done by Rodriguez in 2001. You can also use that formula, the featural model, to apply it to artificial intelligence by using case-based reasoning and using n-tuples and certain parameters that will allow you to measure the similarity between two objects or two terms. You will have two, this gets into a much more complicated formula that I'm not able to explain, or maybe not even to understand, but you have local similarity when you're taking into account certain features that are being held as similar or as dissimilar. And then you have global similarity, which is kind of a weighted sum of local similarities between those two objects. And this as well can be performed by machines. So you can discuss the model, but this has been tested and it has a fair amount of success to the extent that I know. Now, one aspect that I wanted to point out, now getting into the feasibility of similarity and analogy in artificial intelligence, is do machines when they perform similar judgments of similarity or assertions of similarity, do they show the bias? And I don't want to label it as bias because it is discussed whether it's a bias or if it is a bias, if it is a good bias or a bad bias. But does it show two aspects that Amos Tversky developed in the 1977 paper, Features of Similarity, which are directionality and diagnosticity. So directionality, Tversky basically says that when we are performing a similarity judgment, which is intrinsic to analogical reasoning, we are always comparing a prototype, which is a source, to a variant, which is a target. So necessarily we have, and Tversky basically says, this was written in 1977, that North Korea is more similar to Red China than Red China is similar to North Korea. So there's a directionality there because logically, of course, the similarity relation is transitive, but psychologically is not transitive because it doesn't go the other way around. And what is interesting to know is when you're feeding that information to the machine, will the machine fall prey to that directionality as well? Because it impacts the weight that similarities have when you have a certain direction. So it also depends on the way, not the weight, the way that you are feeding the information into the machine. The other symptom is rather more interesting, which is the diagnosticity principle. And the diagnosticity principle, I think it's rather relevant for a similarity in AI. It basically means that the classificatory significance of features has a paramount importance in similarity judgments. So the importance or prevalence of the classifications that are based on these features will impact the outcome. Better explained by the example. Tversky basically makes an experiment with, I think it's Austria. Austria is the country that is the prototype. And then we have Sweden and Poland and Hungary. And 70 students are asked to say which country is more similar to Austria. And Hungary wins, I don't know, because of the Austrian-Hungarian Empire, because Hungarians are also tall. Doesn't matter. Sweden wins. Sweden wins. That's the way, because they're very tall as the Austrians. And then Tversky replaces Poland with Norway. And because Norway is much more similar to Sweden and Sweden is much more similar to Norway, then Hungary just gets much more similar to Austria. So this goes to show that by adding or subtracting objects, this can alter the categorization of the remaining objects because it changes the similarity relations intra-category. This is actually also very important for judgments of equality in constitutional courts, because when we are performing judgments of equality, we are also taking into account the terms of comparison and the similarities between those terms of comparison. So the inclusion of a new source in AI, and I have no evidence to show that this has resulted in terrible conclusions, but it may result in terrible conclusions, because one should be very careful when one is adding or subtracting, but specifically adding new sources in the AI database, because they may affect previous analogies made by an AI system. Also in the human brain, of course, but not as easy in the human brain to make an error as it is in a machine. Now, shortcomings. Shortcomings when we start talking more about analogical reasoning. Current situation, and I will take Melanie Mitchell's word for granted in 2021, is that no current AI system is anywhere, and I underline anywhere, close to a capability of forming human-like abstractions or analogies. I'm always saying this for people to say, no, you're wrong, this has happened, and I'm very curious to know that, but this is I think where we are. Why? Very briefly, and then we can discuss in the Q&A. AI systems do not experience stuff as the cat. So the cat experienced stuff, and he was wrong because it was the liquid. He thought it was the liquid stuff and not the hot stuff. But AI systems do not experience stuff. So we have the knowledge elicitation bottleneck. Not only it is a lot of work to insert data in the machine, but you have the problem of describing knowledge. Like, how can you purely describe knowledge without adding a certain amount of bias or knowledge when you are inserting described knowledge into the machine? Second problem, analogies are used to achieve many different goals. In legal reasoning, you have, let's call it descriptive analogy when you're dealing with evidence and facts. But then you have normative analogy when you're dealing with applying legal statements to other cases to which they were not thought of or they do not prima facie apply to. So we have different types of analogies, and the machine is not able to to understand the goals that were set for each and every analogy. So eventually it will make rather unhuman errors. Other thing is that, and this is also relevant for interpretation, is that Edwin Rislin, can't remember from which year is the paper, but she basically says that and I think she's a bit optimistic. She says that while a host of methods can perform concept learning and classification, for instance, fewer can provide explanations. I don't know if one can provide explanation, but I'm not an expert in AI. And if you cannot provide explanation via analogies with past exemplars, then you really are not setting or striking an analogy. You're just, again, applying rules that were encoded. And since that I'm talking about rules that were encoded, also another rather optimistic statement from I skipped this part, it's relevant, from Liao, Zhang, and Mount. They claim that case-based reasoning, as opposed to rule-based reasoning, avoids the knowledge elicitation bottleneck because it not only parallels better the way people solve problems in various situations, and it also overcomes the drawbacks of rule-based systems, as it does not require an explicit domain knowledge model, and the problem of knowledge elicitation bottleneck can be avoided. So I think this is rather untrue, because even case-based systems need to be encoded with rules, for instance, whether a contrario applies or if analogy is permissible. If the machine is not suitably fed with rules that determine that certain rules will be seen as exceptional, whereas others are just not biconditionals, but normal conditionals that are liable to be subject to analogical reasoning, then the machine will give terrible results. So we cannot just say that, no, this is a problem of rule-based systems. If we use case-based systems, then everything's going to be okay. It's not going to be okay. Third problem I also mentioned before, transferring memory data to cases and situations outside the training regimes. Analogy implies flexibly mapping relations from one domain of experience to another, and classic or symbolic AI models lack the flexibility to apply predicates to operations across diverse domains. For instance, if you insert good faith into the GDPR, he will not know if you're talking about a psychological status. It depends on the context, of course, but it will have a hard time knowing whether if you're talking about a rule of conduct, obliged to act in good faith, or if you are in good faith because you are under a certain psychological status. And the fourth problem is that there is no sufficient consensus over theoretical background theories of analogy. And this is the last part. Time's up.
No. I'm just pulling it here.
Oh.
We have a few more minutes. Yeah.
Few more minutes. How many?
5.
5.
Max.
Okay. 5 max. I will jump some slides. So I already mentioned this. There's two specific problems to analogical reasoning. One is the problem of justification, and this has been discussed prior to my presentation. There's no causality in analogical reasoning in legal analogy. We can, like in descriptive analogies, we can, like the cat can test whether cold water will hurt him or not. It might lack the ability to understand it, but eventually he will get there and he will understand that cold water will not affect him, will not hurt him. So that's a testable scenario. In legal reasoning, scenarios are not testable. So we have semi-testable scenarios, like if you take Fred Schauer's example of no dogs allowed in the restaurant because of the black terrier that was the one that caused the disarray in the restaurant, then if you extract the property of dogness and you apply it to other dogs, most likely the dogs will cause disarray in the restaurant. So there's a good reason, there's a causal relevance not to allow dogs to enter into the restaurant. But if you think about same-sex marriage, and I'm taking the example from Damiano Canale and Giovanni Tuzet, you don't have causality. So you cannot use causality to say that different sex marriage applies analogically to same-sex couples in legal systems that do not explicitly recognize that, because there's not a causal process underneath it. The problem here, that's a problem of justification. The other problem, I already said, is the problem of non-redundancy. I have a hard time understanding how will machines ever perform analogies if they are just applying a certain principle that was encoded in the system. So since analogy necessarily entails that the source is not applicable to the target, because you need to transpose from the source to the target, then the machine will lack the parameter to apply it to the case. If it does apply it to the case, then it's not an analogy per se. It's just applying the principle to the case. And if it did perform the analogy, then this would probably mean that the AI system would be passing the Turing test. I will. 2 more minutes?
Yeah.
Okay. A lot of stuff. So this is basically my tentative description of what legal analogy is. I don't have time to go through it. Just want to focus on 2 specific things: relevant similarity and sufficient similarity. Those are 2 key issues that I wanted to talk about. This is the testable causal scenarios. Now, relevant similarities. problem, this was something that was said in 1992 by David Chalmers and other researchers, French and Hofstadter, that AI experiments were being conducted on the premises that representations were simply structures in predicate logic, assuming a representation module that supplied ready-made representations. Basically, the critique to Dedegenter's structure mapping theory and the structure mapping engine was that it was very easy to encode predicate calculus into the machine and then form conceptual abstraction when the machine does not have any perception of the reality. And basically what Chalmers and others say is that this completely bypasses perceptual processes which are central to analogy in making sense of complex data at an abstract conceptual level. So when we are dealing with relevant similarity, which is something that we humans do, maybe at a certain unconscious level, machines will never be able to do it, or they will only be able to do it to the extent there is some sort of mechanism for perceptuality at the low level of perception. Because the high level of perception, which involves extracting meaning from the low level perceived data, that's the easy way to go about it. That's the tip of the iceberg. But the low level perception, which is entailed in the high level perception, is not carried out by machines. It's carried out by the one who is feeding the machine. So again, it makes it highly incredible that analogies are being performed or will ever be performed unless machines manage to, for some reason, get this low-level perception mechanisms, which are far from settled now. Okay, and just the final slide. Sufficient similarity. The problem with sufficient similarity in general and in AI is that usually it's a matter of decision making, because categorizations are a matter of decision making. There's a neuroscientific study that basically says that categorization equals decision making plus generalization. So you have cases where it's completely random. For instance, if you take Rodriguez's experiment, he basically said, okay, let's put about 80% of the similarity match enough to say that A and B are similar. But that's basically completely arbitrary. Why not 75 and why not 85%? So the noble dream here, and this is the last slide, is will we ever be able, apart from all the stuff that I mentioned, to encode a machine with Eleanor Roche's principles of categorization? So the machine will not have like an algorithm for 80% of local similarities, but the machine would be encoded with the two psychological principles of categorization, which are cognitive economy and mirroring the structure of the world. Because if the machine, and this is a problem for humans to aptly build categories, let alone to the machines, but if the machine was encoded with principles guiding the categorization, then the machine would be able to adapt those two principles of cognitive economy necessary enough to mirror the structure of the world and would form categories instead of having this random value of 75, 80, 80%, 85% standard to strike two objects as analogous. And thank you very much. Sorry for taking more than I could.
You can just turn off the microphone.
Yeah, sure.
Thank you, Pedro, very much for this complex and very interesting lecture. I now open the floor for questions. We can collect them. So, Professor Marco, you can.
Yeah, no, just a quick comment. I think this last thing is very important. I liked it a lot, but I wonder. I mean, my intuition is that the number of properties that things possess is infinite. So I would use that rather for the identification of properties rather than only the identification of similar properties. Partly because the number of things that we can the number of properties that anything has, that you have and I have, are infinite, and so the number of properties that we share are infinite.
So you would use, that?
I would use this for the identification of properties directly. I don't know, this idea of cognitive economy.
Okay.
Okay, what?
Emergent analogical reasoning in large language models, Taylor, Webb, Keith, Hoyak, Hon, Jin, Blue. Strikingly, we found that GPT-3 performed as well or better than college students in most conditions in tasks of analogical reasoning. I'll send you the paper. I just found it.
Okay.
Yeah.
Okay. I can comment on that, but I have no idea what.
Yeah, me neither.
Just tell him they are wrong.
Exactly. Maybe Masha can add something.
No, I'll get to that. Yeah.
Yeah. Professor Farinha was first. Sorry.
Thank you. Just the microphone. Yeah.
There is there.
It's been here all day.
Okay, so excellent as ever, Pedro. I think I know the answer, but actually, now it makes more has more relevance after what Bojan said, because I think that's the question to reply to with, and this connects to low-level similarity, and this has something to do with what we discussed on the podcast. Would you say that one of the things that will help algorithms, machines, AI, whatever, get to that level of low-level similarity is something on the lines of embodiment and emotional response? Because I would probably, if I have to bet, I would probably bet that the object of analogies in the paper that Bojan just quoted have nothing to do with that. And I think that's where, if I got your presentation right, that's probably where we can input the most failure in analogy. We were discussing this at breakfast, which is, for example, if you got shot in the war and you have post-traumatic stress, you will do analogies based on that fact. Machines will not even begin to understand that. They don't have post-traumatic stress. They don't have a body to be shot, so.
Thank you, Masha. Yeah.
I have some technical comments regarding some statements. So a few things, and maybe this is also my misunderstanding, but first of all, you talk about how transferring memory data from training data to test data, that it does it very badly. I completely disagree with that, because you don't test the system on the training data, you always test your system on the test data, which it has not seen. So actually, all the machine learning systems, if they evaluate it in any way, they always evaluate it on the data that the machine has not seen. And if it performs well, that means the system can do this generalization on data that it has never seen. And that's kind of like the idea of why can machine learning do all these things. It's not that it remembers things, but it can generalize well enough to do things on unseen data. So I don't know if this, like, maybe I misunderstood the point there. But the other thing is that you talk about how you feed the machine the rules, you prescribe the rules that should apply so that the analogy would work. But at least from the research that I know about this linguistic experiments with analogies, the idea is that it wasn't actually trained to do that. It was trained to just understand language, and because of like several levels of abstraction that these neural networks could be doing, it actually could infer this without anybody actually telling it that this is what it should be inferring. That this is it was a byproduct of a different system, and that it was able to do so. I'm not saying that it means that it's perfect at doing so, but there's this claim that this is still somebody prescribing it. The rules is just, it does give it the data, you can choose the data that you give, but if you give a large enough corpus like GPT-4, technically you should have like all kinds of all kinds of language connections that should be able to extract it relatively well. I do not trust systems that say that they can do something now, so I don't know. Maybe it is a very hard task, but I don't see why it wouldn't be theoretically possible to do. So the third thing was about this level of abstraction that so it doesn't. It somehow these systems can understand language on some levels that are not just okay. This word means this, or like it has some. I don't like the word meaning, but it has some different words in these models have understanding of how they connect to other words and be able to even like we know that it can create some analogies, so why not all analogies?
Okay, two more. Professor.
Yeah. Well, thank you for the presentation. It's fantastic, and it's too much of information. I'm still trying to process it, but I would love to copy the slides from you. So you talked about directionality in AI, and then similarity as well. So while processing, probably I might have not paid much attention. So is that you said there's similarity in problems, right? Similarity in problems. So according to Daniel Cahill and Samuel Kessler, they've authored a paper titled Algorithms in the Criminal Justice System, Assessing the Use of Risk Assessment. Now, they identify 4 problems that are common among all the risk assessment systems, which is opacity, bias, and lack of reliability and transparency. Would you agree with this? Opacity, bias, and lack of reliability and transparency. These are some of the problems that they found, which is common among all risk assessment.
I'll use that for Masha. So there's a problem with transparency. Well, that's my reply. No, I would. Thank you. I'll get to this. Was a joke. I'll get to that.
Okay, Professor Miller again.
Thank you. I think my first encounter with what is now known as these large language models was like probably 20 years ago or so, when actually I reviewed a book which was published under the name of Thomas Hobbes, and the content of the book were some early essays in which the authorship was unknown, but it was ascribed to Thomas Hobbes, despite the fact that the views in those articles were largely deviating from what he had to say afterwards in his most well-known books, based on the linguistic statistic language model, which was obviously at the time very just in the early phase. And they were picking some, I can't remember what was the kind of the target of picking in the syntax of the sentence, what was the target based on which they kind of comparing it to what he produced afterwards, finding a similarity between the patterns, they came to conclusion that this must be Thomas Hobbes. Subsequently, it was challenged again.
Thomas Hobbes from Leviathan?
Yes. Yes, that one. There.
The large language model was at the beginning.
I mean,
Thomas Hobbes.
because the articles were found much later, and then it was unauthored until beginning of 1990s when somebody used this model. So basically what I understood that you claim is that we haven't moved much from that point, that essentially we can speak of the machine picking up or replicating some samples or similar linguistic patterns or phrases, but we cannot ascribe to this operation the term, the very concept of analogical reasoning. Am I right? Yeah. Okay, so I wanted to kind of understand myself whether I get it correctly. And somehow, I mean, this goes along your claim that what you feed the system with from the European Court of Human Rights decisions were exactly these phrases that likely were leading to success or to the failure of the of the case before the court. So, I mean, it kind of resembles to what you did. But now you said that, and I didn't get that quite well. That machine is possible of kind of generating text without prior working on a sample of the similar text, right?
It has to have similar text, but it doesn't have to have that text. It can produce a completely new thing. So also the same way they can predict decisions for like cases that haven't been judged yet, right? It's not in the system, but I can still do it. In the same way. Like,
but then, then maybe I'm more on your side by arguing that still there is not enough to ascribe to this very operation. Yeah, I can see that there is more to it, but just I think you did the job great.
Okay, please. Mike. Well, thanks. Great questions. Let's see if I got them all, and it gives me the chance to better explain some slides that I put a lot of slides. Sorry. First, Marco, I completely agree with what you said. I tried to mention that not very clearly, but before getting to sufficient similarity, there's the aspect of relevant similarity. And there are some models, and I'm risking because I've never seen those models, but apparently I read there are some models that are called transformational models and models that work with alignments. And those models, they pick up from featural models such as of similarity, such as the one that I mentioned from Tversky, and they use it. They narrow the scope of similarity to roles that are used or played by certain features or objects. For instance, wheel. You have the wheel of the car, but then you have the wheel of the ship if you're getting control of the wheel. So that will be enough to exclude irrelevant similarities between the wheel of a car and the wheel of a ship, or the car if you are driving the car itself. So there's ways to narrow down the relevant similarity so that sufficient similarity will only be struck between relevant similarities, because I completely agree we have infinite properties that would just lead to confusion. Bojan left. Okay, but it was just a comment. So no, but it is incredibly relevant because we cannot show that analogy was performed because it worked. It's not the result that shows that analogy was in place, because you cannot test the soundness or the validity through the result. Otherwise, you can just be mimicking things. And this is the problem, because analogical reasoning is a legal process. And just remember, like in 1953, Alf Ross said that like you are watching two chess players play, unless you have an introspective method and you know that they, before Hart, Ross was speaking about the internal perspective. This is an old battle of mine. If you don't have that internal perspective, then it's just a matter of reproducing. So it's an habit. So it's not legal. It's not legal. So you cannot just like, because ChatGPT did better than 9,000 students or whatever, it doesn't show anything. It just shows that there's a lot of data there. And of course, there's some level of abstraction that allows for that to happen. If that's analogy or not, I think, and of course, the technical aspects, I have no idea. I'm eager to know, but I have no idea. But it just shows that I may be completely wrong, because you can reply to me the following. Listen, that's not a problem of AI systems. That's a problem of analogy per se. Maybe our brain is wired as well with certain information in which analogy is impossible. So we're always applying certain principles that were already encoded through some system or whatever, it doesn't matter. And that's the problem of the non-redundancy problem. Is analogy non-redundant, or is it just applying a given set of, even if very generic principles that when fed with certain facts will allow you to believe that you are striking an analogy when you're just applying data? So maybe it's the same thing and I'm being hyper-rational. I accept that. But if it's not the same thing, which is something that I'm inclined to do, then I would say that even if the machine is 2,000 times out of 2001 right, it doesn't prove that it was striking an analogy. So maybe Tim Humans here, but I don't know. What Domingos said, embodiment, emotional response. I don't know much about philosophy of embodiment. I do believe that the Cartesian duality of mind and body is wrong, and it strikes very close to what David Chalmers said in 1992. You are just feeding the machine with predicate calculus, and what he basically says, I'm not quoting him, but he says that's easy. You just feed the machine with predicate calculus, and then it abstracts and it shows the apparency of an analogy. But what happens in human abstraction and in human conceptual creation is that which is below the water, which is the low-level perception of getting the he mentions the Kant's faculty of sensibility. You have sensibility, and then somehow it gets to the high, so it's low-level perception, somehow it gets to the high-level perception when you're forming concepts. If you're feeding the data for the concepts, then you are bypassing, maybe it's good enough, maybe it's all we need, no problem to predict, but you really can't say that you're striking an analogy, are you? Because you're just feeding the predicate calculus, and that's so. Last two aspects, just Masha again. The problem of not calling analogy per se is that I think it lacks up until the moment where we have a machine that explains this third step, which is the abduction, because analogy entails abducting the best possible explanation for something, then inducting that to a certain set of members that have to which that explanation holds, and then deducting that to the target. Inducting and deducting, that's fine, but up until we have a machine that provides for the best explanation possible for that, it would not be, at least legally speaking, properly an analogy. And I think this is also very relevant for predictions, because if we accept that prediction and explanation are symmetrical, then up until we have an explanation, we will not have a proper prediction. Yeah, okay. and I agree. It's a conceptual thing. I don't want to be, I'm really eager to see a machine performing analogy, and I'm not like being a prick or anything, because we have come an incredible long way. But conceptually speaking, I don't think it's analogy. So thank you very much.
Thank you, Pedro. We can now move on to our second presenter, María Victoria Carro from the University of Buenos Aires. I hope I had pronounced it right. Who is going to talk on the causal inference ability of the LLMs in the legal process.
I have already opened her presentation. It's in a link, I think, on Chrome. This is not.
Can I have your fingerprint? No, but you have to. This is the thing.
Will you be able to, or should I do it?
Yes.
Okay.
But I will keep scanning.
Okay. If you can just move the mic. Yeah, okay. That's
I have to use the microphone.
No, just stand there. It's okay. Not too far away.
Okay. Thank you very much. My research project is about the causal inferenceability of large language models in the legal process. So you can get to the moon by climbing successively taller trees. Today, I'm going to talk to you about one kind of moon, the causal inferenceability of large language models in the legal process. This is a very important moon, or rather a very important goal, because in the legal process, causal and effect relationship plays a central role in understanding the connection between actions and their consequences and determining responsibility, for example. Also, I'm going to talk to you about one kind of trees, the large size in terms of data and parameters of large language models like ChatGPT, GPT-4, Lambda 2, Cloud 2, or BAR from Google. So the main question is, do large language models really perform causal inference, or they pretend to do so through alternative methods? I'm sure you are thinking, what are you talking about? If ChatGPT is fantastic, it can write a story with many causal and effect relationships involved, and it is coherent. That's true, and there are many experts who want to focus on the result, on the progress achieved by large language models compared to previous old systems of natural language processing. Since these new methods establish a new state-of-art accuracy in multiple causal tasks, the role of research should center on leveraging and utilizing these capabilities.
So, stand a bit closer to the mic.
Okay. But what about the unpredictable and fundamental failures? There are many other experts who may say, no, stop. Large language models don't really perform causal reasoning. They are like stochastic causal parrots because their outputs are unreliable mimics that reproduce memorized responses. The term stochastic refers to the probabilistic nature of these models, as they base their answer on a statistical pattern learned from vast amount of data. Just like parrots can imitate human speech without necessarily understanding its meaning. So the next question is, the next question is, what kind of failures are we talking about? What are the specifics of causal inferences in the legal context? Do large language models are able to achieve reliable results in them? So I will show you an example on ChatGPT 3.5. So I gave the model an instruction and an hypothetical case and asked the model to determine if a specific event is a necessary or a sufficient cause of a given result. So let's read the prompt. You are a judge in a criminal court. You are obliged to respond to this question in order to proceed with the analysis of the case. Is Richard shooting a necessary event in causing Sean's death? Can it be considered a sufficient cause of Sean's death? Please provide a decisive answer. And the case is, Richard fires a gun at Sean with the intention of ending his life. However, he aims wrong and missed the shot. The sound of the shot scares away the herd of horses which Sean owned and which was nervy. When frightened, the animals ran over Sean, causing his death. And the model response was the following. In the scenario described, Richard's shootings can be considered both a necessary and sufficient cause of Sean's death. Necessary cause. Richard firing the gun is a necessary cause because it set off a chain of events leading to Sean's death. The initial lack of shooting created the circumstances that directly contribute to the subsequent events. Sufficient cause. Richard's shooting can also be deemed a sufficient cause because on its own it was enough to bring about the death of Sean. While the direct physical harm did not occur from the gunshot itself, the consequences of the gunshot, the frightened herd of horses trampling Sean, were sufficient to result in Sean's death. Okay, what do you think about its response? Personally, I agree with the model regarding necessary cause, and we can employ contrafactual reasoning to validate this assertion. If Richard had not fired his gun, Sean could not have died. Therefore, Richard's shooting is a necessary cause of Sean's death. But regarding sufficient cause, personally I disagree with the model. The shot was missed and the horse were needed to cause Sean's death. The consequence of the shooting is the same event that make it insufficient by itself to cause Sean's death. The horse's race is an important condition that the model didn't take into account and that made the shooting alone not enough to cause death. So this shows us that the assessment of sufficient causes always depends on the context and how much we take for granted as background for our decision. For example, if a ladder of water is empty, pouring water into it may be considered a sufficient cause for water overflowing. But if the glass is already absolutely full, one more drop into it may be considered a sufficient cause for it to overflow. Both events may count as sufficient cause and therefore as causes of the same result. So perhaps the last example was quite difficult for ChatGPT. So there is another example, a more basic example, on a larger model, GPT-4. So let's read the prompt. The kitchen flooded, my pip broke. Which sentence is the cause of the other? And the response of the model was, in this sequence, the kitchen flooded is the cause and my pip broke is the effect. This implies that the flooding in the kitchen occurred first, leading to or coinciding with the breaking of the pip. Okay, again, it made mistake. And this is because the model is basing its response on the form or on the order of events in the sequence or in the sentence rather than on the content. So the last question is, given these poor results, how can we enforce the causal inference capabilities of large language models? Yes. Oh, this shows us that large language models, of course, the whole analysis of the case, we have to consider other ingredients like the intention of Richard, for example. But in this kind of test, we are only focusing on the causal and effect relationship of the analysis. And this shows us the failures that large language models made in causal inferences in the legal process. So therefore, the lack of robustness and reliability of their responses. Yes. So the last question is, how can we enforce the causal inference capability of large language models? There are 3 ways to obtain causality. First, from empirical knowledge. We know from common sense that preparing a birthday party for a friend will make this friend happy. But we have to discard these options as machines are not able to learn from their own experiences. The second option is through poor causal reasoning, as causality can be formally reasoned using known procedures and rules from causal inferences. It's a way of mathematizing causality. Certainly, we can code necessary and sufficient causes, but what about the human factors present in this kind of judgment? For example, moral considerations or the inference of normality. Humans tend to consider one event more causal than another when it is morally wrong or statistically infrequent. So, it is possible to schematize these ingredients in a similar way. And finally, there are experts who say that large language models are able to capture the relevant and necessary background of an event from the natural language description of that event. Since large language models are trained on vast amount of text data written by humans, the subjective elements of causal judgment can be encoded as part of large language model internal representation. However, if this human factor can be satisfactorily captured or simulated by large language model from what was learned from the training text data, there would be no reason why this large language model would make unpredictable and fundamental failures. So, the conclusion is, no matter how large the model is, as I said before, and as the expert Gary Marcus say, you can get to the moon by climbing successively taller trees. Thank you very much.
Thank you, Maria, especially for being excellently punctual. We can now open the floor for Q&A. As always, we can collect the questions.
I just have a couple of comments. So I think it's very interesting. You may be onto something big in the sense that, I mean, it's not obvious to me that how they can reason causally. So answering the question, I just have a couple of comments on the vocabulary. So you talk about sufficient causes and necessary causes. I mean, I guess it'd be better to talk of necessary conditions and sufficient conditions. And the difficulty there is that we are not clear on what a cause is in terms of necessary and sufficient conditions. So it'd be weird to expect that an artificial intelligence would be clear about it. But the way in which they reason on it certainly may drive interesting intuitions. The other thing is causal inference. Definitely, it is a kind of causal inference what you're asking it to do, but it's not the same kind of causal inference or that we were talking about before. Because that thing it can do. I don't think it can do it, really, but there are some people that think that it can do. What you're asking, and in that situation, you're asking to identify the effects of causes in that scenario. Whereas what we're asking in the legal trial, and I think what you're asking it to do now, is to infer the causes of effects. Which is a different thing. So one thing that perhaps you could focus on is on how you disentangle the causal question. There are several different causal questions that we ask, and causal inference as a term is ambiguous over the two. I would think that normally when we speak of causal inference, we speak more of the first that I mentioned. What are the effects of causes? Whereas in the trial scenario, it's more, what are the causes of effects?
Thank you.
Do we have any more comments, Masha? Yeah.
I always have comments. I got in the mood. First of all, for the record, I'd like to state that I'm on the side human, not on the side of the machine, even though I built the machine. I also very critical of the thing. So yeah, it's a very different perspective, of course. First of all, I've checked, and as of today, this thing will be resolved by ChatGPT in a fine way. Their pipe caused the kitchen. To me, it was it's a very sort of linguistic comment. Is that to me that phrasing that it had, the prompt, was very weird. Like and this is like sometimes problem with the evaluating this kind of machine. Again, I agree with all your points, but it's a strange way to evaluate it because nobody speaks like that. Nobody says my kitchen flooded, my pipe broke. Usually we speak in a much more linear way. We already say that they present things in a linear manner. So I'm like quite happy with the way that this system performed. Again, it doesn't do it anymore, but the fact that it took into account the way at which it was positioned, not only the meaning of it, because in terms of the meaning also, you can go on and say, okay, the kitchen flooded and a different type of pipe broke, or the flood did cause a different pipe to break, and so on. So it could actually be interpreted that way. So it's just it's just a comment on the fact that, yeah, it's also important to look at how these things are evaluated. I am pretty sure you can find a lot more examples where it makes mistakes like that, but that was a strange one for me.
Okay.
Just the mic.
Yes. About the first thing you told me, I agree with you. I think in law, we have a lot of theories of causation. So first, I think that maybe we have to agree with one theory to ask the machine to apply this theory. And secondly, yes, there are two big types of causality. One is actual causality, and the other is general causality. And so as my research project is about the causal inference ability of the large language model in the legal process, I only focusing on infer effects on a particular event, about a particular event, not about general causality. There are experts who are assessing all types of causality in large language models, and I use the style of prompt of these experts that are from the artificial intelligence field. I am trying to adapt this kind of research in the legal context, because I think that it's necessary that we start to think about this kind of topics. So there are a lot of benchmarks to test causal inference in large language models, so I will expand my research, and I will try to use a lot of kind of prompt to assess causality. And in law, in Argentina, we, for study law, criminal law in particular, we use laboratory cases of criminal law that are quite strange. when you study, we use very strange cases. So this is. I have my case from a class of criminal law, probably. So thank you very much.
Thank you. Okay, so we're slowly but surely approaching the CLF courtyard reception and the informal parts of the conference. And last but not least, we have, as I have announced, Novak Vujičić, our dear colleague and soon to be assistant professor at our faculty, who is going to talk on the emergence of AI, a need for a new rebalancing of copyright. So without further ado, I give the floor to Novak.
Okay, just to put the presentation. Hello to everyone. First of all, before presentation, I would like to use the chance to thank you, Professor Spaić, to inviting me and giving me the opportunity to be here tonight with you and this very inspiring gathering. And also, I want to congratulate the ALF team for the organizing this conference, and Miana also. Yeah, so that's and now I had the opportunity to participate. This is my second event in this Legal Philosophy Week. Yesterday I was in a conference of libraries, and today I'm here with you, legal philosophers. As you can conclude, I'm not someone who is from the area of legal philosophy, legal theory. My practice area is intellectual property law, and I deal with the interaction of intellectual property law and digital technologies. And a few years ago, I decided not to, because was doing researching in this area for a very long time, and I decided to start to research some basic traditional topics, and then I emerged. So then I again switched to this digital part. My topic is I will call my topic. It could be like guest topic to this conference because it's not in the area of legal philosophy, and it's basically not something. It's not tackling some substantial issues. It's more like an overview of current state of affairs in a copyright law and its relation to artificial intelligence. And the title is "The Emergence of AI: A Need for a New Rebalancing of Copyright." I use this term rebalancing to express my skepticism towards prediction that the AI will bring fundamental change to copyright law, and I will try to explain that in the course of my presentation. My presentation is divided into 3 parts. First part is introduction, in which I will try to explain what is the copyright law and clarify why rebalancing of copyright law. In the second part, I will tackle more into the AI-influenced rebalancing of copyright, some explanation and examples. And at the end, I will try to provide some concluding remarks if that's even possible at this moment in copyright law. So I will start with the first question, and that's what we need to know about copyright. Copyright is, in essence, a construction of balance. We have many interests, and this copyright is constructed around them. On the one side, we have interest of copyright holders and interest of authors. They have interest related to investment, production, and generally creating the copyrighted works. And they want to have some economical return from their creation, and also want to achieve some being able to control the being able to control the cultural use, creative control over those works. On the other side, we have interest of users and interest of general public. They want to use the works for during their other activities, and also they want to have the access to those works. And what elements of this balance are that the copyright has really strict specific requirements of protection. Also, you know that the principle of originality, not all works are protected. Also, we have a limited number of moral and economic sub-rights. You heard about reproduction right, distribution right, making available right, and the others. Also, these sub-rights are additionally limited, and there are exceptions and limitations which are introduced to as some kind of acceptance of some larger social interest. For example, the most we call it famous, but most known exceptional limitation is the free usage of work in non-commercial and private purposes
reproduction of works for that purposes. And also we have a limited duration of this as the element of disbalance. So how disbalance is achieved? What determined the center, the rest point of this balance? There are many factors, but I want to focus on factors of technology. The copyright is dependent in relation to technology. If you say it emerged, but it was established after invention of Gutenberg's printing press, and generally we cannot imagine usage of copyrighted work without technology for exploitation and for dissemination of copyrighted work. So as technology progress, copyright law need to progress together with it to encompasses it all in its field of, if we say field of power, but field of its where we can have the copyright protection. For now, we are coming to the question of artificial intelligence. Artificial intelligence is a new technology that bring us to the question of the balance. Is the copyright again out of balance? Because we have a new questions that copyright asks, that artificial intelligence is asking the copyright law. AI bring many questions for copyright. The most predominant ones are, do AI outputs enjoy copyright protection? This is the copyright regime of AI as a creator, copyright treatment of AI as a creator. And the second one is, does the AI training processes infringe copyright? We have the copyright treatment of AI as a user. And these questions are they're asking for some kind of solution, and I call this rebalancing of copyright law, because copyright law needs to adjust a little bit of its rules to adjust these two requirements posted by artificial intelligence. And as we know, artificial intelligence is quite important for society, and we hold this conference all this week. We are now, I think the whole world is talking about artificial intelligence, and we have a lot of expectation from it. And we don't want unnecessary obstacle for development of copyright of artificial intelligence. So the copyright could pose some obstacle, what does that mean? That means that we are coming to the clash between interest for protection of copyright and interest for the development of artificial intelligence. And that brings us to this out of the balance point and need for the further balancing. So I wanted to provide you a few examples how the copyright and artificial intelligence interact together, and there are I call it two examples of this rebalancing of copyright. First one is less successful one. It's tackled the question: do AI outputs enjoy copyright protection? We all know, and today we talked a lot about interpretation and generation of law from generative artificial intelligence, but we know that also generative AI is making some products that resembles typical copyright works, as songs, movies, short videos, some text, pictures, photographs. And if they were created by a human, they would enjoy copyright protection. So creators of AI they saw, and they still are trying to pursue the protection of their works in the area of copyright law. Copyright seems as an adequate right for protection of these AI outputs. But what was the problem? The problem was that in order to protect AI with copyright, we needed to change the requirements for copyright protection. And though requirements are really strict, they ask for some kind of human intervention. More precisely, we have the principle of originality, and originality emanates from the human, from the person, and that was and also the principle of originality is one of the fundamental pillars of copyright law. So if we want to encompass AI outputs in copyright protection, we need to somehow adjust or change a principle of originality, and that's a fundamental change. And this idea had really, there was a certain period of hype among the copyright scholars about idea of, some differently interpreting the originality principle and introducing AI, but this bubble of hype start bursting after a few decisions of United States Copyright Office, which rejected protection to some AI created works. And earlier this year, we also had the case, the United States District Court also rejected the protection of one AI created work. So, what this shows that probably at least in this level of development of AI, it cannot trigger a fundamental change of copyright law and copyright rules. And that's because I call this not accepted, a less successful example of rebalancing of copyright. Copyright is maybe, it's not maybe, it certainly is ready for some adjustments, but not for this fundamental changes that someone wanted to be done. And generally, that's interesting. Every time when new technology arrive in the area of copyright law, the many scholars want for some fundamental changes, and AI is just one of them in a row. In the last 20 years, we have internet and the computer programs, but neither of them change fundamentally the principles of copyright law. So the second example of this rebalancing that I want to point out, and that I think is more successful, and I think it's the way in which the copyright will incorporate AI in the future. This is this rebalancing example. It's tackling the question: does the AI training process infringe copyright? This question, does AI can infringe copyright, was not the first question that was asked when we consider AI and copyright, but in the last few years, it's getting more and more attention, and I think that's that's important, and I find it that was appropriate. So what is here the question? We know that we talk a lot about learning models. The AI needs some data for its training, and that data can be protected by copyright. And then that brings us to the question: if AI train on the copyrighted data, is it infringing copyright on that data? Also, we have some kind of debate around that. There's those scholars and those copyright experts that think that they're representing I call them pro-infringement group. They are just relying on the broad right of reproduction. That was right of reproduction is one part of the copyright as a whole. Reproduction right, if you probably know, is really broadly defined. Basically, every action with the copyrighted work in digital environment can equal reproduction. At the moment, for example, I'm just starting the PowerPoint presentation. I'm reusing this software. So with this broad interpretation of reproduction, the training of AI in this database, scanning with this data, maneuvering with these databases are certainly represent a fact of reproduction. But what was those are the arguments of this infringement group of the scholars, but there are others who are saying that these acts of reproduction that happen during the AI training are just incidental, that they not have the separate economic value, so they should not be considered a reproduction. But this is just the theoretical question, theoretical arguments, and they not have a practical significance at the moment. But and this clash of arguments is obviously not solving this problem, but the legislator came here and they proposed the solution. The solution is seen and it's acceptable from the both sides in introducing the special exceptions and limitation for text and data mining that would allow AI to train in this with text and data mine in this base in databases. But also here we have the debate: what is appropriate text and data mining? Where is that balance that should be achieved? So I wanted to point two examples how the text and data mining could be arranged in copyright law. First of all, I don't know how are you familiar, but when introducing exceptions and limitation in the area of copyright law, we have two approaches. First approach is European Union approach, and generally European approach which requires that limitation and exceptions are enumerated in legislation. They need to be precisely prescribed in copyright acts. And the second approach is the common law approach, and it's based on the application of the doctrine of fair use. Basically, the courts on a case-by-case basis are deciding is there fair use in a specific case, and this fair use doctrine is applicable in the United States. And because this put a bigger burden to the European legislature, because they need to introduce these exceptions previously, they cannot wait to this case happen in the practice, and let the court to solve them. They need to act preactively. So in the European Union in 2019 there was directive. The directive on copyright and digital single market was adopted, and it introduced two new text and data mining exceptions. One is for the purpose of scientific research. Its scope of application is quite limited. The only research organization and cultural heritage institution can apply this text and data mining exception, and it's quite strong because it could not be overridden contractually. But the interest and the whole attention was on the second text and data mining exception. That text and data mining exception was for everyone else. It can be used for any kind of purposes, but there is a catch. There is an opt-out option for the right holders. So right holders can opt out and decide to not to declare that they don't want their works are subject of this text and data mining exception. So currently we talked here about EU AI Act. It's tackled a little bit, but more indirectly the copyright law. And we will see what will happen in the European Union regarding this text and data mining exception. But it became subject of immense criticism by legal scholars in the European Union. What was the problem with this text and data mining exception? The problem is the many scholars said that it was too narrow to somehow accommodate the goals of European Union to be highly competitive in this AI development sphere sector, and in comparison to United States of America and Japan and China, who had more broad, if you can see I put here the fair use doctrine, a more broad text and data mining exception. These scholars argue that this text data mining exception will be an obstacle is too big burden for the further development of AI in the European Union. So why I mentioned this text and data mining exception. At the first place, I wanted to show you how the rebalancing of copyright is currently on. Can be achievable, and this how there are some copyright law provide with this exception. It said that its reproduction right will not be applied in full capacity, but also it brings some obligations to AI. And what the remaining question that I would like to ask at the end was, where is the new rest point of the balance of copyright protection in the era of artificial intelligence? I think it's too early to predict that. I think that we only can say that copyright will continue to rebalancing, to adjust, not to totally change for the purpose of artificial intelligence. And it's interesting because currently we in the area of copyright law, we still didn't not manage to tackle all the issues of the internet technology. So the AI technology is just bringing more questions, which are just waiting for to resolvement. So, but this time is different that we have AI, and maybe AI will be faster than humans in providing some solutions or some suggestions for its copyright status. That would be it from me. I know that this presentation is out of the topic of the conference, but I think I provide you with some regulatory overview in the area of copyright law, and maybe you get an idea how this to approach this topic from the legal philosophy point of view, and to maybe see some problematics which we who mainly research the regulatory systems cannot see. Thank you very much.
Thank you, Novak, for an excellent presentation. Although you say it's out of the scope, I would completely disagree. It fits perfectly into the topics. Now we have the last discussion part. Anyone has questions, comments? Okay, Professor?
Yeah, thanks a lot. Interesting talk. I was always one of the old guard who said this is not an infringing use. This is purely incidental, long before we had the exception. Then the legislator came, as you say, in Europe and created an explicit rule on the exception. I still wonder what the status of that exception is, and it can play out, I think, in two ways. One possibility is to say, well, we do not address as legislator the issue of incidental copying, but we clarify it to the extent that at least non-commercial mining of things for which you have a license to access is permitted. But it doesn't resolve the question of incidental copying. That is my preferred interpretation. Obviously, I would say it merely clarifies part of the question, but doesn't change the law. One could argue, I agree with that, by the sort of reasoning that it's the exception that proves the rule. There was an explicit exception created. That must mean there has to be a rule that prohibits it normally. I can't see that in the travaux préparatoires. I can't see it in the discussion. I would simply be interested on your view, but my position would be the mere fact that the European Parliament created an explicit permission for text mining under certain conditions doesn't preclude the argument that all the other copying is also permissible because it is still incidental and there's just no infringement taking place. We don't have to worry about exceptions. Exceptions only are reached when there was an infringing behavior. There is no infringement when I have this purely incidental copying. So I would be interested if you think this is still feasible as an argument.
I can answer.
We can collect.
Okay.
Professor María.
Yeah, thank you, Novak. I mean, maybe you did not want to deliver anything from the philosophical point of view, but that does not mean that we cannot ask you philosophical questions since you are with us here. Now, I was thinking about the especially from the point of view of our law, copyright applied to works of originality, and originality is connected to the authorship, so it has nothing to do with the creativity, with the newness. Nothing new should necessarily be produced in any meaningful sense of the word. So if we go back to what we usually, how we perceive, for instance, the works in, I don't know, music or literature that was generated by artificial intelligence, do you think that we would need some sort of adjustment of the initial starting point of kind of originality tied to the authorship? Because we have some sort of work that was produced, and it's questionable how to dismiss it. On what ground you can dismiss this as not falling under the protection of intellectual property? So it has to be something which goes against either originality or authorship. You see what I'm... Okay, so that's my question.
Professor Lopes.
Okay.
Thank you. Thank you very much. That was very interesting. Perhaps it's just a comment on while you were speaking, when you mentioned the doctrine of fair use and now the issues of originality. I just remembered this incredible paper that I read by a judge, almost a confession, written in 1929, called "The Function, Judgment Intuitive, the Function of the Hunch in Judicial Decision." And it's about the patent case. And I will just read very quickly. So basically the judge said, as a scholar, he paid homage to the law's supposed logical rigidity and exactitude. I believed in and practiced logomancy. I felt a sense of real pain when some legal concept in which I had put my faith as permanent, constructive, and all-embracing opened like a broken net, allowing my fish to fall back into the legal sea. I believe that the great tragedy of the law, paraphrasing Huxley, was the slaying of a beautiful concept by an ugly fact. So he's completely obsessed with exactitude, and rightly so. Then he goes on to say that there are several ways of judging a patent, like copyright, or first, the cogitative, of and by reflection and logomancy. Second, aleatory, of and by the dice. Third, intuitive, of and by feeling or hunching. And fourth, asinine, of and by an ass. And in that same youthful, scornful way, I regarded the last three as only variants of each other, the results of processes all alien to good judges. And then all of a sudden, I'll skip to the end, he gets a case about a patent. And he said, I remember once in the trial of a patent case where it was contended with great vigor on the one side that the patent evidenced invention of the highest order, maybe originality, and with equal vigor on the other that the device in question was merely a mechanical advance. I announced almost without any sense of incongruity that I would take the case under advisement, and after having well and exactly seen and surveyed, overlooked, reviewed, read all over again all of the briefs, authorities, and the record, would wait a while before deciding to give my mind a chance to hunch it out. I proceeded according to custom, got my hunch, found invention and infringement, and by the practice of logomachy, so bewhirled my opinion in support of my hunch, that I found myself in the happy situation of having so satisfied the intuitive lawyer by the correctness of the hunch, and the logomachic lawyer by the spell of my logomancy, that both sides
accepted the results, and the cause was ended. So basically, this just goes out to say that you can provide criteria for originality, for invention, for whatever. This text is, I'm not saying that I agree, but it just goes to show that you, in certain situations where is it an invention or is it not, or is it originality, is it original or just a mechanical reproduction, Judge Hutchinson just says, hunch it out. So what do you think about this?
Sorry for taking so long.
Okay. Let's start from the beginning, from the first question. I think what the European Union legislature has done by prescribing the text and data mining exception explicitly, first, when we read it, before that, it was not certain whether text and data mining is at all reproduction. There was a lot of talks about incidental use. But now, when we read this textually, as you say, now we can say that the text and data mining is certainly a part. There is an, I don't know, we have a ground that we read that as the text and data is certainly a part of reproduction. So I think I can say that you can never exclude some arguments. They always have some point, but I'd so much narrowed the maneuvering ground for those arguments. So now I think that the copyright legislature in EU did not help so much AI. It basically has done that it certainly put its copyright hand on AI protection in this area of AI as a user of copyrighted work. But we will see what happened when there was the national laws should implement this text and data mining exception last year, I think. So we will see how the case law will develop. But because some I don't know, we call it these products or mechanisms of EU legislature get their own lives that go in some different direction than it was perceived that they will do at the beginning. And now we are coming to this philosophical question about there is where I agree with you. There is the problem with, we have some creations, generative AI produce some creation that probably should deserve some kind of protection. But I'm from those skeptics that don't think that copyright law should be copyright should not be the right way to protect them. And there are many scholars who are suggesting that we introduce some kind of new right, which will be related right, not the copyright law. And I think that copyright should insist as much as it can on its principle of originality, because that principle is the fundamental of copyright, and that somehow make a difference between copyright and related rights, because when copyright we create, it exists because we want to protect the human products, human creativeness. But on the other hand, we have related rights that protect some investment in creativity. And I think the related right probably should be a good option for protection of outputs of AI. But currently we are in a vacuum. We don't know. The European Union, in the Europe, we have that strong author's right, because we all our national legislation prescribed that strong author's right, which is author-centric. Author as a human is in the center. So I think this change, if it comes, that the attack or somehow dissolving this principle that of originality, and must come from the United States, and or some other jurisdiction, because you cannot, the French and German who nourish their author's right, they will not firstly give up of this originality principle. And generally in copyright law is subject to various interpretation, and I think the principle of originality can develops itself in time because we have new arguments. It's a different society from its beginnings, in comparison to its beginnings, but I'm not sure that it will change so much that it's introduce AI, non-human creator. That's and especially in Serbia. I think Serbia, and from the point of our view, we should wait a little bit to see what the other will do with that, because currently, not with text and data mining exception. In that area, I think we should introduce it as soon as possible. But with this is the interesting thing. When we had the technology of this scale was the internet and computer programs. And if you look on the world level, they could not agree how they will protect computer program, how will they protect the usage of copyrighted works on the internet. And there was one international convention in Geneva, and they make the global standards. But it's interesting at this perspective now how they make the global standards for AI copyright protection, because we not have the world which is united as in the end of the 90s. So I probably will have different levels and different regimes of protection in different areas of the world. And that's not typical for copyright, because copyright is basically harmonized on the international level, and it's a very high level of harmonization. So we can talk, United States have its own way of copyright, but also it's harmonized with that international standard. So that was my answer. And the answer for your question was that I think that we should protect, and it's my opinion as a skepticist, that we should stay and not give up of our principle of originality. I don't know. I think that the artificial intelligence must be on much high level of development to put up that principle in question, or just introduce the related right, and we will protect that on some other way. So thank you.
Thus ends the academic part of the second Belgrade Legal Philosophy Week. I thank you all for coming. The day was wonderful for me. Also, the day before this one, in which you all participated. It was a great pleasure discussing these issues, and I think we'll have many more opportunities to discuss them. Of course, after the conference, maybe a few days after the conference, we'll talk about the possibility of publications if you're willing. It was great hanging with you in the academic part. It was great having these discussions. And it will be great hanging with you in the non-academic part, or one of the non-academic parts, because we are finishing the week and going to a reception in Center for Legal Fundamentals. Thank you all, and thank you all, and thank you, Miona, for the organization of this.